pleasure now to introduce the Dean of the Law School, Linda Ammons.
Well, good afternoon, everyone. And I see we have some media people here too. I recognize that mic. Welcome to everyone to our Diversity Week here at the Law School, which kicks off our annual Martin Luther King Day commemoration program. I'd like to start by thanking Professor Heyman and the committee and all of those who are responsible for today's activities as well as the week. This year's program is special because we are honoring a very special man and because we have a very distinguished guest with us today to help with that effort. I want to say welcome and thank you to our distinguished speaker in the person of Professor Leland Ware, the Lewis Redding Professor of Law and Public Policy at the University of Delaware. I also want to thank and welcome some very special guests who have joined us for today's program, and they include, first of all, the Honorable Murray M. Schwartz, former Chief Judge of the U.S. District Court of Delaware, and the recipient of our very first Martin Luther King Semester of Service Award. Thank you. I don't know whether some of these persons have arrived yet, but I don't want to be remiss in recognizing them if they are here, since my notes were last updated. And they include the Honorable Stephanie Bolden of the Delaware House of Representatives. I don't know if she's here or not. I do know that she's here. State Senator Margaret Rose Henry. The Honorable Janet Kilpatrick of Newcastle County Council. And her husband, Vincent A. Lofink. I don't know whether the Honorable Joseph Radar of Newcastle County Council has arrived yet or not. All right. And of course, last but not least, I want to welcome our honoree, Newcastle Councilman J. Street, and his wife, Vale. Would you please stand? Councilman Street, thank you so much for allowing us on this occasion to thank you for all you've done for our community. Today is special too because we are launching our 5th annual Martin Luther King Semester of Service program, a wonderful service project. One of the things that makes our law school special. I'm very proud of this. Last year, our students contributed over 1,000 hours of service through this project. I think you ought to give yourselves a round of applause. And I think this year we're going to even top that. So that's the challenge from your dean. Before we get started, there's one other announcement that I'd like to make that I was just made aware of as I was coming in this afternoon, and it's always a great announcement. We have just learned that the Martin Luther King Semester of Service Award will now be permanently endowed by some anonymous givers, and I'm thrilled about that. So let's give them and us another So we're going to get started now, and to introduce our distinguished speaker, here is the chair of our Faculty Diversity and Accommodations Committee, Professor Bob Heyman.
Thank you, Dean, for your welcoming remarks and for your support of the Diversity Committee and of this program. And I'd like to take a moment to thank the members of the Diversity Committee, many of whom are here this morning, this afternoon now. Dean Barbara Ayers, Professor Ed Osei, Dean Leonora Ruffin, Professor Jean Sabarge, Celeste Williams, and Dean Serena Williams all made this special program possible. So thank you. Get one out clapping. And on behalf of the Diversity Committee, a special thank you to Professor Hodis, who sacrificed a day of instruction in the Administrative Procedure Act so that he could bring his students to the program. And to the students in that class, the Diversity Committee would like to say, you owe us. As Dean Ammons suggested, today's program is special partly because it is multifunctional. It is our Martin Luther King commemoration program. It is the launch of Diversity Week. It is part of our celebration of Black History Month. It was only because of a failure of imagination that we couldn't tie it to President's Day. But in honor of Groundhog Day, we are going to repeat the entire program again tomorrow and the next day. Mostly the program is special, though, because of what we commemorate, of what we celebrate, of what we honor, and that is the courage and the conviction of some local civil rights heroes. Last year, we honored a hero of the bench, Judge Murray M. Schwartz, who at considerable risk and perhaps at considerable expense did what he saw as his judicial duty and forced the state of Delaware to desegregate its schools. Judge Schwartz, it's great to see you again, and I'm pleased to be able to say once again, on all of our behalves, thank you. And if I may too, I'd like to thank this year's honoree. The plaintiffs, through much of that desegregation, the Coalition to Save Our Children, were led by a young community activist named Jay Street. And the children they sought to save, and the children Councilman Street has relentlessly defended, were not just some children, not just the neglected, not just the forgotten. They were all children, our children. My own son is in the 5th grade in the Brandywine School District. They're off today. He had a choice between staying home and playing video games and coming to today's program. He ain't here. But he didn't need to be here today to celebrate diversity, because thanks to our children's advocates, every day in his classroom he gets to celebrate, he gets to live diversity. It's a priceless blessing, and I'm very grateful for it. Thank you. And no one in Delaware, no one in the world has chronicled the struggle of our local civil rights heroes better than our featured speaker. Leland Ware is the Lewis L. Redding Chair and Professor for the Study of Law and Public Policy at that other school in Delaware. He is a graduate of Fisk University and of the Boston College Law School. He worked in private practice in Atlanta, Georgia, was a trial attorney in the Civil Division of the United States Department of Justice. He was a professor at St. Louis University School of Law from 1987 to 2000 when he was named the first Redding professor. He teaches civil rights law and employment law, and his scholarly works include Brown versus Board of Education, Caste, Culture, and the Constitution, which was awarded the Langham Prize for Legal History in 2004. He's also the co-author of a new book on desegregation, Choosing Equality, Essays and Narratives on the Desegregation Experience, which features interviews with Judge Schwartz and Councilman Street, and a foreword by Vice President Joe Biden. It's a great book, and you should buy multiple copies of it. It is my great personal pleasure to introduce our guest speaker, a wonderful co-author, a wonderful co-teacher, and a wonderful friend, Professor Leland Ware.
Well, thanks, Bob, for that very nice and generous introduction. The co-author he forgot to mention was him, or is him. So you can get that book on www.amazon.com. We are gathered here today to honor Newcastle Councilman Jay Street, who has been and is a relentless advocate for equality. And I thought of the best way to talk about Jay's many very significant contributions is to talk about school desegregation in Delaware. So I'll do that. So I'm guessing that everybody here heard of Brown versus Board of Education. You made the 1954 decision that declared segregation in public schools unlawful. You may know that 2 of those cases arose in Delaware, and they were handled by Lewis L. Redding, and that's the chair honors his memory. And so Brown was decided in 1954. There were actually 6 cases from 5 jurisdictions. In addition to Delaware, there was the District of Columbia, South Carolina, Kansas, and the District of Columbia. And I like to tell people that Thurgood Marshall did not argue Brown. He argued the South Carolina case. Robert Carter did the Brown case, and Brown just happened to be the first case on the list. So what happened in Brown was that the Supreme Court did not decide in 1954 how its decision would be implemented. So it held another hearing in 1955 and issued a decision that us lawyers like to call Brown 2. And in Brown 2, the Supreme Court deliberately issued an ambiguous decision in which the cases were to be remanded back to the trial courts, and desegregation would proceed with all deliberate speed. Now, I'm sure the judges thought it might take a few months or a couple of years to get this done. They didn't think it would take 50 years. But what happened was the southern states seized on this deliberate speed language to delay, to frustrate, to do nothing, to enact laws, state laws prohibiting integration of schools. So from 1955 to really 1968, virtually nothing happened. There were, I think, by 1963, about 1.3 of the schools in the South were desegregated. So finally, the Supreme Court stepped in the mid-1960s and said there's been too much deliberation, not enough speed, desegregation has to commence immediately. And then in 1968, in a case called Green v. New Kent County Schools, the Supreme Court held 2 important things. One was that the school boards had to prove that they had eliminated all vestiges of segregation, root and branch, and so that it shifted the burden from the plaintiffs, the minority school children and parents, shifted the burden from them to the school districts. So that was when desegregation began in earnest. And in another case, in about 1970 or so, the Supreme Court approved different vehicles for achieving desegregation, including busing to promote diversity in individual classrooms. What happened, though, was this. The civil rights lawyers saw that if the segregation plans were limited to just the cities, such as Detroit or Chicago or Washington, D.C., for example, those school districts had become, the populations in those school districts had largely become black, and that school desegregation could not be achieved unless the suburban school districts were included. So in a case called Milliken versus Bradley, the lawyers sought to do that, and they won at the trial court level, but the Supreme Court held that suburban districts could not be held responsible. The suburban districts could not be included in desegregation plans unless the plaintiffs showed somehow that something the suburban school districts did resulted in segregation, in that particular case in Detroit. So that left the vast majority of the school districts, suburban school districts, off the hook, except for a couple, one of which was Newcastle County, Delaware. So that brings us back to Delaware in about 1968, when the state legislature enacted the a law, I can't think of the Schools Improvement Act, was that it, Bob? The Educational Improvement Act. And that law said that, among other things, that any school with 12,000 or more students could not merge with any other school district. Now, the only district that was affected by that law was the Wilmington School District. So it prevented, it acted to inhibit Delaware's duty to desegregate its schools. So there had been a case kind of pending called Evans v. Buchanan, and a motion was filed in the early 1970s to activate that case. And ultimately, in the mid-1970s, the trial court held that that law, along with other practices such as segregated housing patterns, state actions citing, for example, public housing, that through a variety of different factors, the state and the county and the local officials had taken action that contributed to desegregation in Wilmington. So the court ordered one of the very few metropolitan remedies. So at first, the Newcastle County was consolidated into a single school district, and then later it was divided into the current configuration, which is 4 districts, with a part of Wilmington being in each of those 4 districts, and including one part of the Christina district, which is not contiguous, but is down 15 miles away in the Newark, Delaware area. So from the beginning of that process in the mid-1970s, Councilman Street, I'm so used to calling him Jay that it's hard for me to, Councilman Street and many others were involved in monitoring the process, to making sure that things were done equitably. And there were some recalcitrant districts. Red Clay in particular had to be brought into court and ordered to comply with the court's desegregation order. Jay led the group called Coalition to Save Our Schools. That group was substituted as the plaintiffs in that case, and for the next almost 20 years, Jay and his group fought to make sure that the schools districts complied with their duty to desegregate. Now, what happened, though, was that the Supreme Court in the early 1990s decided 3 cases that had a very significant impact on school desegregation. And in those 3 cases, Jenkins, Freeman, and Dow, one Oklahoma case, Missouri case, and the suburban Atlanta case, the Supreme Court held that instead of having to eliminate all vestiges of segregation root and branch, which is obviously far-reaching, the Supreme Court held that school districts only had the obligation to comply with the desegregation decree in quote-unquote good faith, and that they had eliminated segregation to the extent practicable. Now that may not seem like much, but it's a much more relaxed standard. And after that new standard, school districts across the nation were being released from federal court supervision. And then in one of the cases, the Supreme Court held that in the DeKalb County, in the suburban Atlanta case, the Supreme Court said that if single race or mostly black schools remain as a product of the private choices of individuals, that would not prevent a unitary status finding, that is, a finding that the schools had fully integrated. So that even if there were some all black or 90% black schools, that simply reflected the choice of the parents in terms of where they chose to live. So that those rulings then resulted in about 1995 with a motion for unitary status in Newcastle County. Jay and his group fought hard. They said that there were vestiges of segregation continuing in terms of student performance, discipline, white kids being tracked into the talented and gifted programs, black children being tracked into the lower track, so there was actually segregation within schools. But applying this new standard, this new, more relaxed standard, the trial court, and later approved by, confirmed by the Court of Appeal, affirmed by the Court of Appeals, held that the Newcastle County schools had achieved unitary status and that they could be released from federal court supervision. So just 4 years later, just about the time the ink dried on that order, the state legislature enacted the Neighborhood Schools Act. And the Neighborhood Schools Act was basically an anti-busing law. And it is written in race-neutral terms, but it mandates that students be allowed to attend schools closest to their homes. So because of the continuing levels of residential segregation here and elsewhere, the schools in the United States, not just Delaware, are slowly beginning to resegregate. Now let me explain why that is the case. In the early 1930s, during the Great Depression, housing, there was a lot of foreclosures going on, so the federal government stepped in and created an agency to help people with foreclosures. And it created something called a residential security map. And it mapped every city in America, and it rated the neighborhoods A through D. A was the best neighborhood, Anglo-Saxons, no immigrants. The D neighborhoods were minority neighborhoods or black neighborhoods. They were red line. A red line was drawn around that neighborhood, and the lenders were told not to make loans in those areas. So later on, in the 1940s, the suburbs as we know them were constructed totally or almost entirely with the help of FHA-insured loans and Veterans Administration-insured loans. Now, the VA and the FHA had a policy that they would not insure a loan unless it had a racially restrictive covenant in it. Now, a racially restrictive covenant says who can live there and who can't live there, and it prevents sellers and subsequent purchasers from selling to racial minorities. So as a direct result of state action, the federal government action, the suburbs were segregated. So it was not until the late 1960s, with the passage of the Fair Housing Act, that there was any opportunities for blacks to live anywhere except in inner city communities. So these neighborhoods, segregation was a construction. It was a partnership between the federal government and the real estate industry to keep neighborhoods pure and to exclude minorities from those neighborhoods. So the Fair Housing Act was enacted in 1968, and there has been some movement of African Americans to suburban communities, but the vestiges linger on. And in fact, so that the large metropolitan communities, Philadelphia, Washington, et cetera, they all have the pattern is the same. The inner cities are occupied by low-income minorities, more affluent whites live in the suburbs, and that is the condition that prevails unto this day. And in fact, John Logan, a demographer at Brown University, issued a report late last year which said that over the last 10 years, segregation in large metropolitan communities has grown indeed worse than it had been previously. So the whole point of busing was to try to overcome, and other kinds of student assignments, was to overcome the residential segregation that persists, that existed then and that persists now. And so it wasn't the private choice of individual families, as Justice O'Connor said, it was the private choices of white families, because blacks had no choice as to where they could live. So the assumption is simply false. There are a room full of studies that show this year after year after year, and as I said, the most recent one was John Logan's 2010 report. In fact, you can go on to the New York Times' website. It's called Mapping America, and there's a GIS interactive map that shows you every census tract, and you can just look. And I've been writing about this, and if you look at a chart, you get one thing. And if you read the numbers, but when you see that GIS chart, it's kind of startling. It's kind of scary because the segregation is just so stark. But what happened? The last Supreme Court case, the two cases consolidated. One in Jefferson County, one in Louisville, Kentucky, the other in Seattle, Washington. Now, in those two districts, the school districts had made efforts to make sure that individual schools were diverse. So they had elaborate formulas for making student assignments. And parents in each of those two schools sued because they said that because race was considered in the assignment of students, it discriminated against them as whites. So the Supreme Court, a majority of the Supreme Court held that because race was a factor, that even those voluntary efforts to assure diversity was not lawful. Now, the plurality, 4 justices, Chief Justice Roberts said that race could never be taken into account, but Justice Kennedy was not willing to go that far, and he said that diversity is a compelling justification, and that school districts could do other kinds of things, such as site selection, assignments, and other sorts of things. So where we are now today is that residential segregation persists, and given the trend towards neighborhood schools, schools will continue to be, especially in inner city communities, will have high poverty, single race, racially isolated schools, and the data shows that that is simply a recipe for disaster. So Jay has fought this. He continues to fight this. He's filed complaints with the Office of Civil Rights. School districts are being investigated. So he hasn't given up, and we should not give up. But this idea that somehow this is just people want to live where they want to live, and there's nothing going on, and we're post-racial, and nobody discriminates anymore, is simply not the case to anybody who cares to take a look at the data. It's quite stark, and it's frankly shocking. So I applaud my good friend Jay and his efforts. He's devoted 35 years, at least, if not more, of his life, and he's every 2 weeks he's sending me something about some student who's been mistreated in some school, and he's a persistent guy, and he does all this totally on a voluntary basis. So people talk about Lewis Redding or Littleton Mitchell, both of whom made great contributions to fairness and equality. But Jay, because he can be tough, has not received the recognition that he deserves, but it is because of Jay's leadership that we are where we are today. We still have a way to go, and I'm sure that Jay will continue to push and to yell and to do whatever it takes, and he will always be an advocate for equality. And Jay, I just want to thank you very much for what you've done. Thank you.
Thank you, Leland. That was wonderful. You undoubtedly are now wondering what you can do to get involved. You're probably thinking, geez, I'd like to be able to do something like teach a lesson about desegregation in the Delaware public schools. Are there any opportunities to do things like that? We're now to tell you about some of those opportunities. The director of the Public Interest Resource Center, Dr. Sidney Howe Barksdale.
So to commemorate the birthday of Dr. Martin Luther King Jr., PERC and the Law and Inequality Project invites you to share in the legacy of Dr. King by offering you the opportunity to live his message of service. We ask that you serve 12 hours before the end of the semester. 12 little measly hours. We offer you 2 different options. On one side is the charitable labor options. Those are not law-related. We ask you to provide homework help and mentoring at the Boys and Girls Club, to serve in food banks. We have 4 different options there. To participate in, 5 different options there. Loaves and Fishes in Prospect Park, Pennsylvania, the Food Bank of Delaware, the Bernadine Center, and Share in Philadelphia. Essentially, you'd be bagging food, providing meals for families. There's also the MS Walk in Wilmington on April 16th, and serving as greeters for 2 different events at the Latin American Community Center, as well as a Habitat for Humanity opportunity. All of these opportunities are posted outside the PERC office, and you can just come and sign up. We'd like to do it online, but some of them have very specific limitations, so we want to make sure that we're grabbing them as soon as somebody writes their name down. And then on the other side is the law-related opportunities, and those are the pro bono service options. We have the medical legal project. This year we are surveying patients at the Brandywine Counseling and Community Service Center in Wilmington. The training for that is March 14th. There is the high school teaching project, a lesson on desegregation. It is typically on Parker versus University of Delaware, right? Right, okay. And that training is March 21st. And then there is also the mock trial project, which is this weekend, and we still need judges. So we ask that you sign up immediately, if not sooner. And that is with the Delaware Law-Related Education Center. And it is hosted this this Friday and Saturday, and more details on that at the PERC office. If you have received a brochure, if you want to sign the compact and give me your email address, we can get back to you. But as you see, some of the events are coming right up, so we'd like to, hopefully secure your participation. And if you have any questions, Kristen Crane Lopez is standing right up there. And she and I will be happy to help you with the charitable labor options. And if you have any questions about the law-related service options, Professor Heyman is available. Any questions before I step in? No? I hope you will partake. Thank you very much.
And here, in fact, are some brochures and some sign-up forms for this weekend's mock trial competition. Each year, the School of Law presents the Martin Luther King Semester of Service Award to a member of the community who has lived Dr. King's dream, who has manifested in their life's work those commitments to community service and to social justice that the School of Law seeks in our Semester of Service project. Last year's award winner was the Honorable Murray M. Schwartz, former Chief Judge of the United States District Court for the District of Delaware. It's my pleasure now to call on the Dean, who will present this year's Semester of Service Award to the past president of the Coalition to Save Our Children, the Executive Director of Hilltop Lutheran Neighborhood Center, the Chair of the Delaware Black Caucus, and the Councilman for Newcastle County's 10th District, a tireless advocate for all our children, the Honorable J.P. Street.
Those who work with me and my colleagues in the Delaware Black Caucus and on County Council, very seldom am I at a loss for words. But I am, when Leland mentioned the names of Lou Redden and Lit Mitchell. I had the honor and pleasure, well, first Mr. Redden was my family attorney, but I had the honor and pleasure of being in the room in the 70s as we went into the final stages of going to the 1978 order. I was in the room with the big boys. They wouldn't let me play at the time, but they let me in the room. And Lit Mitchell, who actually, till just before he died, very seldom did I make any significant move without picking up the phone or going to Delaware City and saying, Lit, what do you think? And I didn't make a move. Even if we didn't agree, if it was major, we didn't make any move without basically him blessing it. But I believe right now in the state of Delaware that unfortunately this battle's not over. I believe that the Neighborhood School Act, the Charter School Act, and the Choice School Act are all unconstitutional, and I know they have resegregated our public schools. I may get, as a layperson, one more bite at that apple, but after that, the destiny of what happens in both the achievement gap between people and the gap between the haves and the have-nots in this country, that destiny is going to rest in your hands. Because at the end of the day, lawyers and judges are going to make the final decision. Folks can legislate all they want, but at the end of the day, lawyers in a courtroom making their presentation to a judge or judges is what's going to be the end verdict. So the destiny of fairness in this country actually is going to go into your hands. It's a major, major challenge. I just urge you to pursue it with all the passion and vigor that you can muster, and it's all about making a difference. And finally, I've gotten all these awards over the last several years, but there's one person that never gets recognized the way she should get recognized. With every successful man, with every successful woman, there's a spouse. And my wife, Billy, she made a conscious decision not once but twice to share me with the community. As coalition chairman, I missed a major part of my kids growing up, and JJ got into something in high school once. It was the only time she complained, but I can hear it now. Coalition to save my, you better get home and save your own. And at the unitary trial, things got real ugly. And I'll just leave it as they got ugly. So much so that I promised her, look, when I've got to get through trial, but once trial's over, I'm done. And I promised her faithfully that's what I'd do. And then she looked at me 4 or 5 years later, she said, you're not happy unless you're out there, so just go. But remember, you're going, not me. And I just want to say thank you for being so supportive and for doing the things that I couldn't do with our kids. And the ultimate sacrifice in this whole process as a family was yours, so thank you.
Let me just say, in addition to the token of our appreciation that has been given the councilman, his name is now permanently inscribed on a plaque that is displayed here at the law school in perpetuity. So thank you so much for all of your contributions to the Delaware community. And not only the Delaware community, because what happens here often is the impetus for things that happen other places. So we thank you. Lastly, I think Representative Stephanie Bolden came in while we were, after I had already recognized her. But would you please stand so that you can be properly acknowledged? All right. I believe this concludes our program. We have a reception out in the Alice and Walter Strine Atrium, which is just out this door to my left. I thank you so much for coming, and go out there and help somebody.